Okay, so tonight we're going to talk about fixtures and secured transactions. And a lot of what this conversation about fixtures, when I talk to you about fixtures, we are not on. When I talk to you about fixtures, what comes to mind?
Like fixtures?
Fixtures in general, fixtures.
Like real property.
Real property, the fixtures. What are the fixtures in real property?
Attached to the house.
Attached to the house. The lights, the fans, the artwork that was custom made for the property put in, installed. All of the things, the surround sound system. A lot of people, believe it or not, when you install surround sound, you put wires in, you put speakers in your house. That's permanent. It's meant to stay unless you write in your contract that it's coming out. Question?
My house is already pre-wired for it, so I put one up, so I can't take it with me. Unless I take it out first.
You can take the speakers, you leave the wiring in, but you also make sure you write in your contract that you're going to take it.
I'll just say the brackets from the previous owner.
Well, but write it in your contract, because what'll happen is you'll sell, you go to a closing, someone will come back and say, but you didn't say anything about this. It's always best to put all of that in writing in your contract.
So let's take it out before you show.
That's the whole idea. Anytime you show, if you're a salesperson or you're somebody selling your own house, if you don't want the next owner to have it, you want to take it with you, get it out before you ever show the house. Then nobody's going to question what it is. But if it's there and there is question, you don't want to remove it. It has sentimental value. You think it might be months before you sell your house. You got a family. There's a lot involved in getting a house, making the move, making things happen, and you forget to take it out. Make sure you do. We've got pages and pages of exhibits you can do on these contracts, and that's where you list all the property that's staying or all the property that's going. And you can make it affirmative. You can say, any property listed here is property that's staying, and write it. Or any property that's listed here is property that I'm taking, everything else will stay. You can make it any way you want it, work with your agent to word that in the contract, but make sure that's all in writing so people do understand. And I don't know why I don't... Well, I'm going to go on and talk through this, and we'll get there. So basically, it's fixtures. So what do we want to talk about tonight? What constitutes a fixture? What makes it a fixture? Real property, is it attached? Describe different types of attachments. How do we make it attached to the property? Identify different tests for classifying our fixtures, and explain how a creditor can perfect its right to personal property. And this whole thing with creditors is primarily in commercial real estate. And I'm dealing with that right now with a lease that we're doing. We're building a salon suite. They're borrowing a bunch of money to build out their space. So their creditor has come to us and said, we want our application to be ahead of the lease, to have priority rights to be able to, if this company doesn't make it, and they're spending $600,000 to build out the space, we want to have priority rights to come back. Now, if they go out of business 2 or 3 years from now, their mortgage company that lent them the commercial construction mortgage isn't going to come in and tear that out of the building. But what they will do is try to preserve fixtures. They will take fixtures. They will take things out of they're not going to tear down all the drywall, but they'll take some of the fixtures out of the building. They won't take the AC unit out of the building because the landlord's providing that. But if the tenant was providing that, and that was part of the loan, they try to make that part of their list. Things that can be removed. You can take an AC unit out. You're not going to take all the ductwork out. But an AC unit is a big piece, big component. Sinks out. I had a yogurt shop down in Parkside, Frankfort, Kentucky that went out of business a couple years ago. And the creditor came in. They removed all the yogurt machines, everything. They took all the tri-sink out, the freezers out, everything that was there. Except the built-in countertops. We had a tenant come in a couple months later, and he said, I want to open a new yogurt shop. Well, the leasing agent didn't bother to tell him that there's no equipment anymore. It's all gone. It was all used to satisfy the creditors. And he walks in and he says, I can't open a yogurt shop. I thought all the equipment was going to be here. So, I mean, they took out 8 yogurt machines. Those yogurt machines had a value of probably $10,000 to $12,000 a piece. And they took them out, and interestingly enough, the guy that came and took them out, he sold a few of them that very day while he was taking them out. He sold a couple of them for $12,000 because he knew he was going to make money. But again, that's That's the bankruptcy part of it. That's coming back and taking property and trying to liquidate the assets. Okay, so how do they perfect their right to the property? I do not know why our screen is not coming on. It's acting like it's gonna go, but I don't know what it's doing. I'm gonna keep rolling through here so we stay on track. Okay, so a fixture. It's personal property that's become so attached to the real property that it loses its identity as personal property. So, think about something just really quick. What do you think, I'm going to focus a little bit for you, go into a kitchen. What do you think is personal property that becomes so attached it becomes part of the property? Thinking about a kitchen. Dishwasher. Refrigerator.
Stove oven.
Huh?
Stove oven.
Stove, oven. The island, because an island, yeah, it's probably just attached with a couple nails. You could lift it out. What about the microwave?
It depends on if it's like built in with the cabinets or not.
Right, depends upon if it's built in. If it just sets into a niche, a microwave, I'm sorry, it plugs in. It's ready to go. But if the niche is custom built around what that microwave is, that's meant to stay there. If it matches the stove, or connected to the stove top. It's part and piece of the stove. A stove, how is a stove hooked up to property?
Gas line.
If it's gas.
Right.
If it's electric, how's it hooked up? Plugged in. If it's a gas stove, it's a gas fixture. The idea behind gas is it's plumbed in. It's supposed to be permanent. But what's involved, why are you doing that?
It takes 2 seconds.
I was going to say, it takes 2 seconds. When you know how to do it, it takes 2 seconds to pull it out. You cap off the gas line, or you turn it off and you know, it's ready to go. So I'm going to challenge all of you, and I'm going to say, is that refrigerator, is that stove, is that really personal property, or is it really a fixture?
If it's included in
Her magic words. What did you just say?
I said if it's included in the deal.
Okay, years ago when we sold houses, we always assumed that all the refrigerator, the stove, everything was going to stay with the house. Never assume that. Never assume that.
When my parents were selling the house and they had to write up the property name, they had to ask if they were including it all. And we were getting all new stuff delivered just for the sale of the property. And we're like, yeah, we're putting it in there. And they're like, well, sometimes people take them. And I'm like, no, they're going in.
Right.
They were just brought here.
But, okay, so in some of our contracts, there's actually now a checkbox that says it'll stay, or you tell people it's going to stay. Never assume. These are things that unplug easily and walk away. If you're buying investment property, a 4-family or a 2-family, and the stove and the refrigerators are there, that should be part of the bill of sale. You're buying an investment property, you should get a bill of sale that says all of those things are fixtures that come with, but they're really personal property. That's what a bill of sale does. But we assume they're all going to stay. So anytime you're dealing in real estate, buying, selling it, never assume any of that. Always make sure that it's in writing, or there's a checkbox or something in the contract that has that stuff covered. Place set in the backyard. That's the built-in place set. It's poured with footers and everything.
Fixture.
It's a fixture. It's meant to stay, and that was the intent of the owners. Okay, I'm sorry. I just got 2 little kids, and I want them to grow up playing on this place set, but, oh, sorry. We're moving out, and the kids are only 6 and 8. We're going to move out a little earlier, and I want to take this place set with me to my next house for the kids because I had it custom built for my kids. But it's a fixture. It should stay. Again, but you can negotiate that. If I take that out of the ground, what do I got to do?
Move it.
Going to remove it, but I
Disassemble it.
I want to disassemble it. I want to repair the ground where the footers are. I want to fill the holes where the footers are. But so, again, never assume that's going to happen. I'm going to turn this off and then I'm going to turn it back on and I'm going to try to get it going. See if that works maybe. Maybe I don't have a thing tonight. Okay, so personal properties become so attached to the real property it loses identity. It passes with the transfer of the title to the real estate. The title to personal property remains in possession of the holder and does not transfer with the sale. All right, I'm going to give you an example of something that is titled, but you think it's going to stay with the property, You live on a 5-acre farm and you're selling your farm, but you have a trailer, a double wide on the lot. Does the trailer stay or go?
If it's on wheels, it goes.
It's on wheels, it goes. What do we do with most trailers today that are double wides? We put them on blocks, we skirt them. We've never attached them to the property other than through the sewer line, the electric lines and things like that. But we skirt them to make them look like they're more permanent. But in Ohio, trailers are personal property. They're sold with a title like a car title is. So again.
Does that vary from state to state?
Yes, it does. It does vary from state to state. So that the mobile home or the trailer is personal property. So know when you're dealing with these kind of things, what's customary for your area, how's it going to be handled?
Even the double wide.
Yeah.
It's up on blocks and skirted.
It's up on blocks and skirted, but it can be put on wheels and rolled away very easily. Yes, yes. And when you actually go into trailer parks where people are trying to sell their trailers and move on, that's always title work that's done. They don't own the lots anyway. It's a lease on the lot. They rent the lots, but they're going to give their title to the trailer park owner, so the trailer park owner can transfer the title to the next, or they're going to do a direct sale. So a fixture test. Courts are going to apply such tests in the following. I'm going to turn this off, and I'm going to turn it back on. It's going to take a minute, but I'll keep talking. Courts apply tests of the following. The intention, the agreement of the parties. Okay, so that's while we're negotiating our contract. What's the intention, the agreement of the party? Or the next thing is the intention when the property was bought, when the personal property was bought. You had that bench custom designed to fit in the house. You made curtains, custom curtains to fit the rectangular window that's a funny rectangular shape. It's really skinny and tall, and you had a custom, or that big stained glass window. You had a special curtain made to fit over that stained glass window. Those are things that were made custom for the property. They should stay with the property. What's a curtain though? It hangs on a curtain rod. You just pull it away. Or a window blind that you have made custom for the property. Again, if you had it made custom for the property, the idea is it's supposed to stay with the property, but you never assume that. Character of the property, the adaptation, the actual constructive annexation. Again, a blind, you're going to put little hooks in, you're going to fasten it. A curtain rod, just on hooks and fasten. But again, because it was built specifically for that window. These mini blinds are sized for these windows. Anytime you get mini blinds, they're, quote, sized for the windows. So they should stay with the property. Again, not a lot of things we're thinking about, but you're buying a home. It's a lot of touchy-feely things. Then you start thinking about it. And also the fixture test, substantial harm. If you're going to remove it and it causes substantial harm to the building, to the property, then you're going to say, that's supposed to stay. That's permanent.
That's monetary harm?
Physical harm.
Physical harm?
Physical harm to property.
What about gym equipment? I mean, I'm going to assume it's the same. So, for instance, we have a room on the back of our house, and it's a decent sized gym, and it's more like the CrossFit, if you know anything, big bars and all this other stuff. So it's nailed down to the concrete. We did all the concrete work ourselves. So we can repair it if, we tear it up and there's some type of damage, but same would apply since it's like nailed and attached, like a swing set.
Yeah. Yeah, again, so this is one of those things. You want to make sure that your contract's very specific that says the gym equipment is leaving or staying.
Okay.
Just very specific. Then it's not a problem.
Okay.
Okay, so I show up to a closing. The theater chairs. This was a house in Hyde Park. This was my one house that gave me the creeps. It had a little. I only had one. Seriously, with all the houses I used to deal with, the trust department, I was there for over 4 years. People die in houses every day. But this was the house I went into, and the hair on the back of my neck stood up every time I went to the house. And stupid little things happened. And I swear to God, that house was haunted. And by the way, stigmatized property, what do you have to tell people when something's stigmatized? You never volunteer, but you have to answer yes or no. If somebody asks you the question, yes or no.
Somebody died in the house, right?
Somebody died in the house. But you never have to volunteer it. So we finally got a contract. People were in the driveway, were writing their contract, and they finally looked at the realtor and said, somebody died in the house? And yeah. She didn't have to tell them how, but yes. And it was a violent death. And I think that's part of the whole thing. The lady was crazy anyway, but so she didn't leave her house for the last couple of years. Getting Jenny and Sex came to see her with truckfuls of stuff. She bought designer clothes. She had too much money. She enclosed her pool so her dog could swim. Just weird kind of stuff going on. But this house had been a ranch house, and people added on to it, and they had a spiral staircase that went down to the basement to have early days of the cinema in your house, the home cinema. And they had a screen up and everything, and it was everything they could do to get those chairs into that basement. A niece inherited the house. It took us months to get the house sold. We go to the closing, the chairs were gone. My customer, or the people that were buying the house, they're like, they did the pre-inspection. They said, "Where are the chairs?" And she's like, "Well, I took them." Well, we didn't know to write anything about the chairs. They're theater chairs. Anybody can buy them. They're lounge chairs. Pick them up and go. It took effort to get them in and out of that room. But the people that were buying the house wanted the chairs. This was an $800,000 home. I looked at the niece and I said, "It's $3,000 worth of chairs. You bring the damn things back. We're going to have a closing. Because it's not going to cost you the sale of this $800,000 home. Get it done." And that's what taught me very early on about making sure all this stuff is in writing so you don't get to that point. I don't know if we're going to have a PC tonight, guys. We'll see what happens with vision. Okay, trade fixtures. Trade fixtures are personal property installed by a business the tenant used in conducting a trade or business on the premises. Just about every retail store you're going to go into has trade fixtures. That's the cash rack area, the display cases, all of the shelving that they're putting their merchandise on. Those are all trade fixtures. Last Tuesday, I got to make a trip to Chicago. Got late home and lost home, but I was going to look at Toys R Us stores, 2 buildings that were Toys R Us that closed down. And they were full of all the trade fixtures. All Toys R Us did was get all the merchandise out of the building. And I was lucky. My 2 stores were actually cleaned up. The restrooms were cleaned and everything was. But some of the other stores in this portfolio, they had graffiti all over them. They weren't so pretty. My stores in Chicago were pretty nicely cleaned and done, but full. I'm not kidding you. It would cost over $50,000 in each store to have all the shelving and racks hauled out of the store, just from the sheer volume and weight and the amount of racks that are in the store. But those are trade fixtures. When Toys R Us filed bankruptcy, they left all of their stores like that. They didn't have money to pay people to haul that stuff out. They left all that stuff like that. When we get notice that Elder Bierman's store up in Dayton, I closed that one on the 31st of August. We got a notice from their liquidator that said, "We're giving up our lease as of today, and any fixtures and any merchandise that's left in the building is considered abandoned. We've done what we have to do by the courts through the bankruptcy." So they abandoned everything. My estimate to get everything hauled out of that Elder Bierman store was $30,000. Now, they're nice tables, they're nice racks, they're nice things, but it costs money to move them
Why
out.
wouldn't you do an auction? Just get rid of liquidated, get rid of it.
They did an auction. They had liquidators there. They were selling merchandise. They were selling racks and stuff, and they were selling them for months, but they couldn't get them all claimed, and they couldn't get them done. Is it worth my time as a property manager to do that kind of stuff? I don't think so. Would I find a salvage company that's willing to come take whatever? Well, guess what? All the valuable metal stuff is gone. What they left was wood and glass and other stuff that doesn't have recycled content. They got to have your stuff out. And I mean, I visited the store several times while the months that they were closing, and they had haulers in hauling stuff out every day. But they still have a bunch of stuff. Well, the way this is going to turn out, the next tenant that's coming in more than likely is going to spend $1 million to $2 million to demo the entire interior shell of the building and rebuild it. They're going to haul it out. We're going to let them have it. We're going to give it to them. Now, if they come back through their lease negotiation and say, "Sorry, no, we're not going to do this," there's a cost, then we're going to have to come to terms with the next tenant. And we told their contractors, we walked through with their contractors, I told their contractors, everything you see here is part of demolition. So depending upon what cost they get. Again, that's not been negotiated yet. We're in the process of still negotiating a lease now. I'll have to see what's going to happen.
Does it make it a lot harder for you to sell the space to a tenant if there's a bunch of trade fixtures like that?
Well, because they're gonna bring the ceilings down, they're bringing all the interior walls down, they're gonna have a bunch of crews there with dumpsters and stuff anyway. I'm adding a few more loads. You know, it'll cost me $2,500.
Is that amount not really like that, like it doesn't put really a dent into like a negotiation?
It could
Like
be,
the 30,000.
the 30,000 I got was from you got junk, we'll haul for you kind of a place. For their contractors to get rid of it while they've got dumpsters and stuff they're going to landfill, it may be another 15,000. It could be with their time and labor. So it could be a point of negotiation. I haven't seen it yet, the lease yet, to see what's gonna happen. I haven't heard about that yet. I'm sure I will.
Well, like I was just thinking, like if they're gonna spend $1 million to $2 million.
Oh, that's chump change.
Yeah, that's $15,000.
Yeah, that's $15,000. And that's why I said, when I walk through with their contractors on the walkthrough to let them look at the building, I told their contractors, anything you see is, all the makeup counters, all that stuff is staying. Because it's attached to the floor, they gotta unbolt it. And then the wonderful thing about all those makeup counters and everything, they all had electric in them. They had cash registers in them. How do you wire all that stuff that's in the middle of the floor? There's big troughs cut into the concrete to drop the wiring in. So when they redo this store, they're gonna pull all those things out and they're gonna have to fill the floor with concrete. And the finish of this tenant is polished concrete floors. So they'll fill it, then they'll polish the concrete floors. And you always see the little lines because it's not the original construction, unless they stain all the concrete. But yeah, there's still to be discussed, to be watched and see. I will know, I'll tell you all in the next few months, this is all gonna happen while we're in class. We'll be negotiating and getting to this point about what's gonna happen with those fixtures. I'm not sure we're gonna get it. Okay, so trade fixtures remain the personal property of the tenant. That's what's magical about this whole thing when you have a tenant in place. The tenant has a business to run. They have to bring trade fixtures in, display cases and things to sell their business. But the tenant has to securely fasten everything because the tenant has liability. If they don't securely fasten all those counters and all those racks and everything, people come in and lean against them or climb them to get, okay, I'm guilty of this. I'm only 5'1" on a good day. Now I climb into the shelves and the counters at Kroger all the time. I try to find somebody tall and I'll ask them to help me out. But if they're not around, I'll climb. I'll go get my stuff. You better bet Kroger's is testing all their shelves to make sure they're sturdy enough for somebody like me to climb. Because I'm not the only one that does it. But that store is liable if I get hurt. I did it on my own. I'm stupid enough to climb the shelves, climb in the racks or whatever. But if something falls down and I get hurt, I'm going to sue them. I mean, yeah, I'm stupid. I'll admit that. But that's the nature of this business. We're going to get sued from the person that trips and falls on our sidewalks. We're going to get sued from the person that comes into our store and does something stupid. That's just the nature of what it is. So we have to securely fasten everything. So there is going to be some damage when those fixtures are removed. What we require in store leases is that they be put back to some kind of reasonable condition. Reasonable condition doesn't mean the floor has to be brand new, but if you took out huge holes, keep the troughs covered, don't take all the coverings and stuff out of the troughs, keep them in place, would be what we would ask the tenant to do. What?
Like I was talking about climbing the shelves and stuff, and like it was your fault when, I mean, since it's your fault, it's negligence, aren't you somewhat responsible for that?
I'm a smart person, I'm in this business, I understand that, and an attorney would probably be able to figure that out and argue that with me in the court of law, but I'm in the business. If you're not in the business and you go climb and you do something, you fall, you're stupid. I'm sorry. You don't know any better? You don't have a lot of common sense? No.
There's no warning sign.
There's no warning sign. Yeah, they're not posting signs to me that say, don't climb the damn shelves, lady. You know, they're not doing that. I had a lady trip and fall the other day in front of a Five Below. What was she doing? Talking on her phone while she was walking. Is that my problem? No, but it's my insurance claim. I want to be able to say, no, you should never talk and walk on the phone. It's, don't, it's chewing gum, walking, talking, and everything all at the same time. You're not supposed to do this, but people do it all the time, not paying attention. A couple years ago, I had a lady trip and fall, and she broke her hip on the sidewalk. And I'm like, man, you hit hard to break your hip. And then I'm asking all these questions, what she do? But it's not my place. All I do is turn to the insurance companies, let the insurance company negotiate. They, in the court of law, in their court of law, they can decide who is responsible. They're gonna say whether the landlord is negligent in maintaining the place. And did we present a hazard for the tenants, for the customers coming into the building?
Who would pay between the tenant and the property owner if the accident happened right in front of, like you had an AT&T store, someone broke their legs because AT&T wasn't keeping up their little section on a snowy day, with the property owner or the tenant?
It depends upon what common areas are described as. In most of my centers on that snow removal issue, the common area is mine is the landlord to clear. So it's not only is it landlord insurance, but guess what else? It's the snow contractor's insurance. When I negotiate a contract with snow removal, he names me additionally insured. So as a property manager and property owner, I'm putting another level in between us. And I had this conversation with my snow contractor the other day when he came in to visit me. I said, he asked me, what's an event? 2 inches of snow. Every 2 inches of snow is considered an event. At what point in time do I have to keep clearing? I got Topgolf, I got AMC theaters. You know, Topgolf is open till 1 or 2 o'clock in the morning. AMC theaters open till 1 or 2 o'clock in the morning. The rest of my storefronts are open until 9 or 10 o'clock at night, except for the restaurants. What areas do they have to shovel all the time, depending upon the time of day we have snow? I'm like, dude, you're the contractor. You're the first line of defense for insurance. It's up to you to do it. Don't overcharge me. Don't come in every half inch and charge me to do all that removal. I can tell you this year, I spent $89,000 in 3 months, and I only had not even $60,000 budgeted because we got hit with more snow this season than we thought. But again, so I'm going to leave that. That's the snow contractor. That's their expertise. That's their business, and they're the first insurance. And yeah, we got to pay the price. Ultimately, who pays the price? My tenants. It's common area costs. We pass those costs all to our tenants. And who ultimately pays for that? The customers, because the customers are paying for everything. So the tenant may remove trade fixtures at any time during the term of a lease and for a reasonable period of time following the termination of the lease in the absence of a contrary agreement. So my tenant gives me notice they're going to close. Again, Elder Bierman. They were trying to sell as much as they could through their liquidator, but when the last day came, I'm not kidding you, they did a fantastic job cleaning that store. They really did. It's a very clean store. They left everything clean. There is no merchandise. It's all just racks. We were able to find a few little things because we were digging through closets. We were turning lights off. We were going through and mothballing the building. But just walking in, they did a really good job cleaning it up. And, you know, I was very satisfied with the work they did overall. But it's still a lot to take it to the next use, what we got to do with it. So they left. They left us and said, gave us notice. Anything we leave is abandoned. It's your property, landlord. And yes, then we could sell it. We could make money off of it. We could do whatever we want. But I'm a property manager. I don't have time to do that. I'm not in a wholesaling business. So we'll try to deal with it expediently the best way we can with a good price. Okay, removal of a trade fixture. State statutes may provide that unauthorized removal of a fixture is a misdemeanor and subject to criminal prosecution. That the wrongful removal is considered waste. Not in Ohio. In other states it may be the case. It also depends upon how your lease is written. Most of our leases are written that say that you're supposed to, we expect you as the tenant to remove trade fixtures. What it comes down to though, when I have a tenant move out and the ice cream shop left and he took, this is another ice cream shop, he took his refrigerators, he took as much stuff as he could, and we told him, dude, the next tenant that comes in is blowing this place away. Go ahead and try to sell as much as you can. He sold his walk-ins. They had to come in and take them apart, but he was able to get a couple $1,000s for it. So, again, it depends upon how is the property manager going to react to that. If he would have left all that stuff, my next user, I was going to be trying to find somebody that would have a similar use, that would have value in that stuff, rather than having to take it away. My problem with Elder Bierman, my next user, they're going to come through, they're going to gut the store. It'll be retail, but they'll set it up, it'll be concrete floors with lots of racking. No built-in walls is what we're thinking right now. So we'll see what happens with that. So it could be wrongful. An injunction may be used to prevent a party who threatens to remove a fixture from doing so. We can go to court and we can say, we heard the tenant is going to take this valuable stuff out of the building. Okay, think about this. How many of you have been in Cheesecake Factory lately? How many of you actually been in a Cheesecake Factory store lately? It's high-end finish. They have very high-end finishes. And I'm sitting there going, what did the landlord pay for this store? You know, what did the landlord pay for it? What did the tenant? There's a combination of things going on to bring the Cheesecake Factory there. And believe me, to have Cheesecake Factory, the landlord's paying a lot. Because Cheesecake Factory brings shoppers to your stores. But they have high-end fixtures, they have high-end finishes and things like that. So if that Cheesecake Factory comes to me and says, we're leaving and we're stripping, I could go to the courts and say, stop. This is high-end fixtures. We as the landlord end up paying a percentage of it. We have an ownership right to it. I can get an injunction done to stop them from doing that. Most cases will let tenants take the stuff. Many states provide for a right of removal of fixtures where an innocent improver acting in good faith improves the land of another. So I am a tenant of this guy and I did improvements because I wanted to live here. I had a trade-off, but I didn't realize this guy really was a tenant too. He really didn't own it. He told me he owned it. I thought he owned it. I did a lease with him. Didn't realize I was a subtenant. And I made improvements to the land, improvements to the building. I have some right to go back to the courts to help me out with that. I'm not at a total loss. It's a fair kind of a system is what they're trying to do. Fixtures taxable as real property. Something that is fixture will be taxable as real property. But if it's not attached and easily removed without damage to the building, then it's treated as a fixture for real property taxation purposes. So you think about this room we're sitting in now. What in this room is real property? How about what you're sitting on, what you're sitting at? All this stuff has wheels. This all wheels out of here. Okay, so that's personal property. The real property is the walls, the ceilings,
Screen light fixture.
the light fixtures. The screen might be. I gotta look at this screen. I don't know about this screen. There is a screen up in the ceiling. I didn't lower it. But this screen is really just, it's hooks. It comes off pretty easy. What about the projector?
No.
No.
It's just plugged in. Yeah,
How's it fastened?
Through the middle.
Yeah, there's a metal brace that holds it.
Goes into the thing,
It's also wired in.
Is it wired or plugged? It's plugged.
There's a wire right here.
There's also a wire on the side.
It wasn't a picture earlier.
So half of you guys are telling me you think that's a fixture, the other half of you telling me that you think that's a personal property piece. So the best thing to do on something like that would be absolutely put in a contract. But I will tell you this, if this building was sold and cleared out, there would be a bill of sale. These tables, all these kind of things would probably stay. And for good measure, they'd list that as part of the bill of sale to make that taxable property.
I got a question. It just that this is arguable, just to put in front of the class kind of thing.
Mm-hmm.
My grandmother had a condo, and she had special lighting put in for all her paintings.
Yes.
So it had built-in wiring that went to the frames, that the lights adhered were part of the frames. So is the argument then that the paintings would have to stay?
They could be considered part of the real property if they were built in. Absolutely. Now again, she dies. She walks away. You all were stuck with this. The executor of the estate, what are they going to do when they sell it? Oh, they forgot to mention any of this. Then all of a sudden this property goes to closing. And you're the people buying the place, and you think, hey, all this stuff's going to stay. You're the people selling the place, and you've already sold the artwork.
Mm-hmm.
So you're going to go to court.
No, she acquired a painting that way too.
You're going to go to court.
Bought
Is what's
property
going to
and they forgot
happen.
to take it off the wall.
Sure, you're going to go to court. And that's one of those things where this is where you absolutely want to put it in writing. Absolutely put it in writing. But because it wasn't put in writing, everybody kind of had their own view on it, I guarantee you that's enough money to go to court. And that's where it's headed. Yeah, not pretty, and it's not the way you want these things to end up going to court. Okay, so Example, an above-ground swimming pool may be considered a fixture and subject to real property taxation. An installed below-ground swimming pool is an improvement to real property, but it's also included in the property value for taxation purposes. So I kind of don't agree with that, but the way they rule it and look at taxation purposes, again, the above-ground pool is personal property, it's taxed. The in-ground pool that's built in, they're going to say it's real property, but they're going to tax it too. And where they're going to tax it is as an improvement. Your real estate taxes are going to go up.
Right.
You're not going to pay personal property tax on it. Your real estate taxes are going to go up. That's what will happen with that. So you have to understand there are different kinds of taxation systems. We have personal property taxes and we have real property taxes. If you live in Kentucky, you pay a combination of both. If you live in Ohio, you pay real property taxes and you don't pay anything for your personal property. He's looking at me like, huh?
I've heard of that,
Yeah. In Kentucky, you have to declare value for your household furnishings. Your car, every year when you go license your car, you don't pay $40 like we do in Ohio. You pay
Hundreds of dollars.
huh?
Hundreds of dollars.
You pay hundreds of dollars
The value
based
of
on your
your
car
car.
value. Yeah. So just over the river, there's a different taxation system because it's Kentucky to Ohio.
We had a house in upstate New York, had an in-ground pool, and we did the Google search just looking at it, and people filled it in.
Uh-huh.
They just filled it in because they don't want to pay taxes anymore.
Yeah.
They love the pool, they just don't want to pay the tax, it was so expensive.
So they just filled it in.
It was like a couple, I don't know, $5,000 a year or something stupid.
Oh, yeah.
Tax, $5,000 tax their pool.
Just because of the value. When they filled it in, it became a non-issue.
Sure. Well,
You're right, yeah.
But wow.
Okay, so I have a storefront. I have Marshall's in Dayton. And Marshall's comes back to me. They pay their share of real estate taxes every year when I get the real estate tax on the center. But they have a provision in their lease. You have to understand, Marshall's is owned by TJ Maxx. So it's TJ Maxx, Home Good, Marshall's. They all hang out together, one parent company. They're really good at writing their real estate leases. So they come back in and say, if the property transfer ownership while we're a tenant, we will not pay for the increase in value simply because there was a transfer of ownership. So when the center was valued before at $20 million, my investors bought it for $30 million. That's a 1/3 increase in value. Marshall's comes back, we throw the tax bills at them, they say, we're not paying our share of that. We don't have to pay our share of that. Our leases, we don't pay our share of that. But we did make improvements to the store. We'll pay you a little more based on improvements to the store. So now we're picking back and forth going, that's interesting. But we can't hit them for that much value. But what we can do when the property reappraises, okay, in Ohio, every 3 years and every 6 years, properties have reappraisals. Every 6 years, down pat, reappraisal. And the 3-year, you hope it holds. That's just our system in Ohio. But what we're eventually going to do is we go back to TJ Maxx, parent company, and we say, dude, the property was reappraised. It wasn't raised. Yes, it was raised in value because there was an acquisition, but now it's purely reappraisal if we've held the property that long. We're going to go back and argue that it is not acquisition. It's purely reappraisal, and their lease doesn't exempt them from reappraisal. So, again, how these leases are worded, how people look at it and review it, and state to state is how this is going to be impacted. Attachments. Attachments are crops, trees, bushes, and grasses that are attached or fixed to the land. So attachments. It's fixed to the land because it grew out of the land. It's fixed to the land through its root system. We have things called fructus naturalis and fructus industrialis. The difference between the two of those. Fructus naturalis is your perennials, plants that come back year after year. There's a root system. Fructus industrialis is the crops that you have to replant every single year. Now we do farm leases for those, and we make money off of our farm leases, but they're considered two different things. They're naturalis or they're industrial, based on how we have to maintain our crop every year. An implement is the right to cultivate and harvest annual crops on land. So an implement would be the farm lease that we do. In Ohio, we have something called CAU value, Cultural Agricultural Use Valuation, CAUV. In Ohio, if you farm at least 10 acres of land, you can get this COV. It's a tax credit. Okay, so when I was running the farmland at Ohio Casualty on Seward Road, it's 130 acres. The building is only 30 acres. 100 acres is farmland or other land. When I took over the property, we were only farming 25 acres. But over time, I had it transferred that we were not farming 25 acres on one tract. We were actually farming and doing things over 60 acres on 3 tracts. And I got the value based on the CAUV down to almost no holding cost for the owners because we knew how the taxes and the stuff works for farming. So anytime you have farmers, these are people that are smart about what they can do to claim reduction in taxes based on the agricultural value, the work that they're doing on their property. Every state has those kind of farm basically incentives to keep farms. Creating and perfecting creditors' rights, secured transactions. Secured transaction is one that is intended to create rights in the personal property or fixtures of others. So like I said, we're doing an agreement with this salon where we are the owner of the property, but we're signing a subordination agreement to their loan, to their construction loan. So we're already placing them in a position of higher value than us. And I guarantee you, if somebody's smart, I'll be able to go to the courthouse the next couple of weeks, I'm going to see that recorded somewhere. If they're fully protecting their rights, they're going to record that lease or that agreement. Because that's putting the world on notice that they are fully a creditor. That's how they want to do that. Okay, the security interest gives the holder of security interest the right to repossess, retain, or dispose of the collateral if the person who owns the obligation fails to perform. So that also is part of that filing in the courthouse, is putting the world on notice that, hey, I got a security interest. I'm telling everybody. Anybody that wants to get involved in this property, I've recorded it. I'm showing anybody that it's out there. Now, you need to know how to go in the courthouse and look up this stuff, but it's there.
What were the rights again for the security interest? It's repossess.
Repossess, retain, or dispose of the collateral. Now again, all of this stuff, you're taking really good notes here. But most of this is stuff that pertains to commercial real estate. You're not going to see this in residential real estate. You won't see things like this on the state exam. You need to understand that there are creditors' rights. There are personal property, there's real property, there's fixtures, but they won't go into the detail on this on a state exam. Creating and perfecting creditors' rights. The other right that's created in a secured transaction is called priority. The holder of security interest has the right to be paid first among creditors with respect to that collateral. This is that whole thing about bankruptcy. And when people file bankruptcy and who their creditors are and who has the first priority to get paid. That's all y'all need to know about this, is that there are priority interests when people get paid. Secured creditors and unsecured creditors. Secured creditors become these people that have these instruments. Unsecured creditors is the rest of us out there. Okay, mechanics can get secured credit based on putting liens on property. They file liens to show that they're due money. And before property can be sold, those liens have to be resolved. That's how mechanics and people get paid their money, if they've been not paid. But this is the same kind of thing. We're just doing a security interest to say we own or we finance that piece of real estate improvements. And then attachment collateral, again, they have to attach, they have to go through a process. They have to give value to the debtor. The debtor has to have rights in the collateral, and the written agreement recognizes the security interest. So that's what my tenant's lending company is going through this process now. Document, create all this paperwork, have everybody sign off on it to establish their rights to be able to come back. That's all they're doing. How they get paid and everything, that's not my business. That's their business and my tenant's business. Security agreement is a contract between the creditor and debtor, and it provides security interest. Security agreement is effective between the parties against purchasers of the collateral and against other collateral. Again, it impacts me as the property owner, as the landlord, because I signed paperwork that said I gave them the priority. But again, they're not going to destroy, they're not going to tear everything out of my building, but they're going to try to remove the valuable pieces that they can. And we've given them the right to be able to do that. But again, I'm not a house where tearing this stuff out is going to leave ugly scars will never be repatched. We're a business. We're a shopping center that gets rebuilt, remodeled all the time. That's the nature of our storefronts. So that's the difference of what that is. Perfection, again, this is the process of going through so that they perfect their debt. They show that they have the right to be able to be here. Allow secured party to obtain maximum protection. They have a time where they have to perfect it. When security interest is attached, security creditors taken possession, and they have financing statements that's filed public records to show this, that they have this interest. Again, perfection is the public act of going forward and establishing the creditor's rights. They're just notifying everybody. Effectiveness will lapse in the expiration of 5 years unless a continuation statement is. So when we perfect, we have 5 years for this whole financing tragedy to happen to go get our money back. It's a 5-year process. It can take 5 years. And the financing statement says who the debtor is, what their signature is, identifies secured parties, and the states. There's also something called a purchase money security interest. This occurs when a supplier of goods advances funds for the purchase of collateral. It applies only to personal property or fixtures. And again, this PMSI, purchase money security interest, these are only things that you're going to see in commercial property. Again, they also have the priority to go in and do the same kind of thing, to go through the securitization process, to file paperwork with the courts in the county to show they've perfected their interests. And that's it for this whole piece. Oh, no, it's not. Defaults and remedies. Okay, what's a default? When somebody defaults on something, what do?
Don't pay.
Don't pay.
Different types of defaults, too, in the like a lease contract, right?
Okay.
Do certain, they're supposed to do something or not, then there's always like some type of.
Okay, I have a tenant down in Louisville that just called me last week when I was driving in Chicago. Joyce, I'm calling you to tell you I want to mail you my keys. I'm going out of business. Well, good. Well, I already reached out to you last week because I also got a notice from your insurance carrier that you quit carrying liability insurance. So that's one of those things you're talking about. They got to carry liability insurance. They're supposed to maintain maintenance agreements on their HVAC equipment. They're supposed to keep their rent current. They're supposed to keep their place clean and free of debris. Those are the kinds of things we're going back to them and saying, you got to do these things to be in compliance with your lease. So if you quit doing any of these things, you're in default. So when I called the attorney to file, I'm going through an attorney, I'm going to let the attorney do the default notice and all that, we listed all the reasons. You haven't paid your rent, you've abandoned the premises. Our leases don't allow abandonment either. So you've gone dark, you've abandoned, you've quit paying insurance, you quit paying rent. So those are our default reasons. So we've listed all those. So we can reduce the claim to a judgment. So we can go to the courts and issue a judgment against these people for closing down. They have another 1.5 years to go on their lease. They basically owe me another 1.5 years worth of rent. That's a contract that they have. Okay, but I'm a commercial landlord. The first thing the courts are going to ask me to do, and any of you that are renting property, whether it's a small single family or 2-family or 4-family, if you're a landlord in a position and you've declared your tenant in default, you're coming back to seek rent, the first thing a judge is going to ask you as a landlord, what have you done to mitigate your damages? What is mitigating your damages?
Stop it.
Stop your damages. Lessen your damages.
Find a new tenant.
Find a new tenant. Get a replacement tenant. So the courts are going to, now my tenant has another 1.5 years to go on their lease. The courts aren't going to help me get 1.5 years worth of money out of that tenant unless 1.5 years time goes by and I've been trying to market the property, I've been trying to do everything I can to get a new tenant in place, and I just haven't been able to. The courts will help me get that money. But the best thing I can do is go start advertising right now. That space is ready.
So if you would do a new lease, it's less than what they were currently, you can make up the difference of that.
Right. So the question is if we do a new lease, let's say his rent is at $15 a square foot, and the replacement tenant's only willing to pay me $10 a square foot. I've lost $5 a square foot for the remaining time on that lease. I can go back to that tenant and say, that's a deficiency judgment. I did my best I could to get a replacement tenant, but there's still a deficiency, this gap that you gotta help pay and make up. Yes, because it's in contract. I didn't make those people sign a contract for that lease. They did that all on their own. Nobody put a gun to their head to open a salon. They wanted to do it. And they did it when times were better. Okay, so seeking a deficiency judgment against the debtor, proceeds from sale of collateral insufficient to pay the debt owed. So that's the other thing we can do. And we did that at the yogurt shop. We tried to sell that collateral. We tried to sell that property. We split the proceeds with the bank and with us. So we were able to get $12,000. So we went back to the courts and said, we got $12,000 as our piece of selling off the personal property. We want a deficiency judgment for the rest. And we never did release that one. It's still sitting there vacant. But we went ahead and we just made a settlement. We hit a hard date and made a settlement. So we're done. So it's just sitting vacant now. And it's my job to keep it clean and make sure I have air conditioning and heat, not air conditioning, heat, so I don't have frozen pipes. I air condition, but just a little so I don't have mold. Okay, so that's it for this chapter.